Hi guys, my name is Kimberly Kadusale and today we're gonna discuss about the court pillar, which is part of the 5 pillar in criminal justice system in the Philippines. Ang court pillar is importante in the administration of the criminal justice system kasi ang court is the final arbiter, which is sa kanya nanggagaling ang mga desisyon sa lahat ng disputes or issues sa lahat ng cases na involving sa violations of criminal law. Dinidinig sa korte. Kaya naman mahalaga ang court pillar dahil ang court pillar na to ay nagbibigay ng huling desisyon kung ano ba ang mangyayari or magiging hatol sa ating akusado. So first, the court. The court is the government body official assembled under the authority of law of the appropriate time and place for the administration of justice, through which the state enforce its sovereign rights and powers. Again, the court is the government body which is not a private sector, no? Kung saan ito ay isa sa sanghay ng gobyerno. Under yan ng pamahalaan ng ating government or under the authority of law. Kung saan ang trabaho niya ay administration of justice. Sa pangangasiwa sa pagbibigay ng katarungan at pagbibigay hustisya sa nangangailangan nito. Every time na may krimen na mangyayari, ang korte pa din ang magbibigay ng huling husga sa ating akusado. So, ang next ay ang judge. So, ang judge ay kinukonsider natin as a referee, which is a public officer so named in his written evidence of appointment or commissions assigned to preside over and to administer the law in the court of justice. Make sure the attorneys, prosecutors, or defense play by rules of the games. And who determines the guilt or innocence of the accused, which is siya yung magpipili kung saan ang inosente at yung dapat ikulong sa kulungan. May mga functions tayo sa court kung saan una, to protect the rights of the accused. Diba ang sabi natin, ang akusado ay inosente until proven guilty. So, we make sure na pinapalagaan din natin kung ano ang karapatan ng akusado. Ina-assure ng ating court to our judge na walang nababiolate na karapatan ang ating akusado. Again, the court is responsible for reviewing the actions ng ating mga law enforcement bodies, ng agencies, ng mga kapulisan natin. To ensure na kung sino man ang nag-handle sa ating akusado ay hindi nila na-violate ang karapatan ng akusado. And the number 2, to determine by the all legal means whether a person is guilty of a crime. Nabanggit na po natin kanina na ang court ay ang function ng court ay nagde-decide sa ating mga controversies, sa mga cases na naisinasampa sa korte. Next, to protect the society, upang magbigay ng pangangalaga sa ating society and reduce the criminal behavior by properly imposing the penalty and the sanctions, which is yung pasarusa natin sa kriminal that will serve now, diba, to deter the future, the criminal action ng ating akusado, ng ating kriminal na ikulong na natin kung ano ang kaparaanan niya, kung paano mag-commit ng krimen. Magsiserve din to sa ibang tao, which is the community, na mag-commit ng criminal acts by properly imposing the penalty and the sanctions, which is yung pasarusa natin sa kriminal that will serve now, diba, to deter the future, the criminal action ng ating akusado, ng ating kriminal na ikulong na natin kung ano ang kaparaanan niya, kung paano mag-commit ng krimen. Magsiserve din to sa ibang tao, which is the community, na mag-commit ng criminal acts, which is or mag-pose ng kapahamakan sa ating lipunan. The last is the administrative rule, which is para sa mga nasasakupan ng gobyerno. In short, sa mga katauhan nila doon sa court, which is there are clerk of court and even the public and private prosecutor. That's are the part of the court, which is the power of government. Kung ang mga prosecutor or mga alagad ng korte, kung may ginawa sila ng hindi tama, ay dapat silang mabigyan ng parusa. Kaya ang ating korte ay may mga patakaran o may nagawa ka bang kabalbalan sa korte. Ang korte mismo ang magbibigay ng hatol sa iyo kung ano man ang ginawa mo sa loob ng korte. So, ang ibig sabihin lang yan, ang ating korte ay may gampanin. Ang ating judges sa mga katrabaho niya or kasama niya loob sa korte. Court is also called court of law. The court provides opportunity for the prosecution to present evidence and establish proof of criminal guilt of the accused. During trial, the accused is given time in the court to disprove the accusation against him. Our criminal justice system abides by the constitutional presumption that any person accused of a crime is presumed innocent unless proven otherwise. This means that the court must determine the guilt of the accused beyond reasonable doubt based on the strength of the evidence presented by the prosecution. If there is any reasonable doubt that the accused committed a crime, he has to acquitted. The rules of court, however, provides that the accused can be convicted of a lesser crime than the crime he has been charged with in the information, but the elements of the lesser offense should be necessarily included in the offense charged, and such lesser crime was proven by competent evidence. There are three functions of court. First, keeping of peace. The primary functions of any court system to help keep domestic peace It is obvious that it is rarely considered of or mentioned if there were no institution that was accepted by the citizens of a society as an impartial and authoritative judge of whether a person had committed a crime, and if so, what type of punishment should be meted out. Vigilance offended by the person conduct might well take the law into their own hands and proceed to punish to allege miscreant according to their uncontrolled discretion. If no agencies were empowered to decide private disputes, impartially and authoritatively, people would have to settle their disputes by themselves, with power rather than legitimate authority likely being the basis of such decisions. Such a system might easily degenerate into anarchy. Not even primitive society could survive under such conditions. Thus, it is most basic sense. Courts constitute an initial element of society, machinery for keeping peace. Second, deciding controversies. In the course of helping to keep the peace, courts are also upon to decide controversies if in a criminal case, the defendant or one charged with a crime denies committing the acts charged against him. The court must choose between his version of the facts and that presents by the prosecution. If the defendant asserts that his actions did not constitute criminal behavior, a court often aided by a jury must decide whether his view of the law and facts of the prosecution is correct. In a civil case, if the defendant disputes the plaintiff's account of what happened between them, for example, whether they entered into a certain contract or agreement, or if he disputes the plaintiff's view of the legal significance of whatever occurred. For example, whether the agreement was legally binding, the court again must choose between the parties. The issues presented to and decided by the court may be either factual, legal, or both. Courts do not, however, spend all their time resolving disputes between the opposing parties. Many cases brought before the court are not contested. Example: divorce or routine debt collection case. As no dispute exists over the fact of the law, the court rule in such cases is more administrative than adjudicatory. Moreover, the mere existence of court may render the frequent exercise of its power unnecessary. The fact that courts operate by known rules and with reasonably predictable result leads many of those who might otherwise engage in legal actions to search a compromise. Because people are typically unwilling to incur the expense of going to court if they believe that there is a good chance that they will lose. Most people arrested and charged with a crime plead guilty. If they do so with full understanding and without any correction, the judge generally accepts their admissions of guilt. The sole question for the court is decided whether the defendant should go to jail a pay restitution to the victim, or be subjected to other corrective treatment. The judgment may entail more than one of these punishments. In, sub- in, civil, in civil law countries, some judicial, some judi- some judicial, judicial, some judicial inquiry into the questions of guilt or innocence is typically required even after a confession. But the injury is generally brief and tends to be perfunctory. Tends to be perfunctory. Perfunctory. The main problem to be resolved is the sentence that should be imposed. The vast majority of civil cases are also uncontested, or at least are settled prior to trial. In some instances, serious negotiations begin only after a lawsuit has been filed. Many suits are settled by the parties themselves without intervention of the court. Because courts are usually under strong caseload pressures, they encourage such settlements. Consequently, in many Western systems, only a small fractions of civil cases are actually tried. Indeed, in many countries, a notable trend of the late ages. The decline in the court usage reflects several legal and social trends, most notably the increased desire of the parties to seek immediate relief and increased options in the systems available to do just that. And the last, the administrative rule, which is to handle matters of public assistance and informations, requests for expeditious actions on pending lower court cases, and other requests that do not need administrative or judicial adjudications. This may include follow-up on status of cases, among others. And also, courts have a responsibility. There are to promote justice in individual cases, to ensure the public perceptions of justice in individual cases, to provide an impartial forum to the resolution of legal disputes, to protect individuals against the arbitrary use of government power, to provide for a formal record of legal status, to deter criminal behavior, to rehabilitate individuals convicted of crime, and also to provide for the separation of convicted individuals from society where necessary. is the jurisdiction which is the authority of the court to hear and try a particular offense and to impose the punishment provided by the law. So, ang sinasabi dito kung saan or saan na korte na paglilitis or hearing or kung sino man ang tatanggap na or kung sino man yung makikinig sa ating. And that's all. Thank you for your time to listen.